Hi there. My name is Sasha Westerman. I am a Florida board certified immigration attorney, and I'm here to talk to you today a little bit about what are the obligations under the I-864 affidavit of support. So this is a question we get a lot from our clients, and more so from what we call joint sponsors, people who are serving as secondary sponsors because the primary sponsor and petitioner does not meet the income requirements on the affidavit of support. So it's a really important question. And I am always very, very honest with everybody, with my clients about the obligations under the I-864. I have mediated cases post-divorce where the I-864 has come into play, and it's not a joke, right? It is something serious. It is a serious legal contract made between the sponsor and the US government to assure that the intending immigrant will not use public benefits in the United States. So I always like to start with the actual form itself. The form itself, where the sponsor signs, has a sponsor's contract written right in it. And I'm going to put it on the
Hi
screen
there.
now.
My name is Sasha
Um,
Westerman. I am
One
a Florida
second.
board certified immigration attorney, and I'm here to talk to you today a little bit about what are the obligations
Here it is
under
on
the
the
I-864
screen. Okay,
affidavit
perfect.
of
So,
support.
Sponsor's
This is a
contract,
question
right?
we
And
get
this
a
is
lot
what you
from
have
our
to read
clients,
and sign
and more
and
so
declare.
from what we call joint
Note by
sponsors,
signing this
people who are
I-64,
serving
you
as
agree to assume
secondary
certain specific
sponsors
obligations
because
under
the
the
primary
immigration
sponsor
nationality.
and petitioner
What
does
is the
not meet the
legal
income
effect of
requirements
signing?
on the affidavit of
It tells
support.
you this creates a
So
contract
it's a
between you
really
and the US
important
government. Like I
question.
was just
And I
saying,
am
under this
always
contract,
very, very honest with
you
everybody, with
agree
my
that
clients
deciding
about
whether or not
the
the
obligations
person will
under
be
the
a public charge,
I-864. I have
that they can
mediated
consider your
cases
income in that
post-divorce
calculation,
where the
right?
I-864 has
Now,
come into
what
play,
does
and
it mean,
it's
right?
not a
What
joke, right? It
consequences
is
are there?
something
I think that's the
serious. It
important
is a
part.
serious
Now,
legal
in theory,
contract made between
where
the
it says
sponsor and
here,
the US government to
that
assure
if someone
that the
uses
intending
means
immigrant will
tested
not use
public
public
benefits,
benefits in the
state or
United
local means
States.
tested public
So
benefits,
I always like to
they
start
can
with
consider
the
your
actual form
assets,
itself.
right?
The form
What if
itself,
I
where
don't
the
fulfill the
sponsor signs,
obligations?
has a
This
sponsor's
person can
contract
sue
written
you
right
for
in
the
it. And I'm going to put it
support. I
on the
mean, it says it
screen
right
now.
there, right? And then it says
Hold
if a
on one
federal, state, or
second.
local private agency covered any means tested benefits, they can ask you to reimburse them for that amount,
Okay, so
right?
here
And
it
they
is
can
on
enter
the
a judgment against
screen.
you,
Okay,
right?
perfect. So
When will these
sponsor's
obligations
contract,
end?
right?
This
And
is
this
really
is what you
important.
have to
Becomes a
read
US
and
citizen.
sign
That's
and declare.
normally, in most of my cases,
Note
the
by
earliest
signing
that
this
people are
I-64, you agree to assume
severing
certain
the
specific
I-864s when
obligations
the
under
person
the
becomes a US
Immigration and
citizen.
Nationality Act. What
They
is the
have
legal
worked
effect
or
of signing?
40 quarters of
It
Social
tells you
Security,
this creates a
which is
contract
10
between you and
years
the
when
US
the person
government.
has
Like I
worked
was
10
just
years
saying,
under Social
under this
Security number.
contract, the person's no longer
Agree
resident,
that
that
deciding
deciding
whether
whether
or
or not
not
the
the
person will be a public charge,
right?
they can consider your income in that
Divorce
calculation,
does not
right?
terminate the I-864.
Now,
So that's something really
what does
common.
it
People will
mean,
get
right?
married, do an
What
I-864, and
consequences
then
are
get
there?
divorced,
That's
and
the
want to get
important
out of
part.
it, then you can't, right?
Now,
It says
in
right there,
theory,
divorce does not
where it
separate.
says here,
Now, the reality is that
that if someone uses means tested public benefits, state or local means tested public benefits, they can consider your assets, right? What if I don't fulfill the obligations? This person can sue you for the support. I mean, it says it right there, right? And then it says if a federal, state, or local private agency covered any means tested benefits, they can ask you to reimburse them for that amount, right? And they can enter a judgment against you, right? When will these obligations end? This is really important. Becomes a US citizen. That's normally, in most of my cases, the earliest that people are severing the I-864s when the person becomes a US citizen. They have worked for 40 quarters of Social Security, which is 10 years, meaning the person has worked 10 years under a Social Security number. The person's no longer resident, the person has been removed, or the person dies. Right? And right here, divorce does not terminate the I-864. So that's something really common. People will get married, do an I-864, and then get divorced and want to get out of it, and you can't. Right? It says right there, divorce is not separate. Now, the reality is that most people have to sign these applications because if you want to sponsor your spouse, your parent, your child, you're going to have to sign an I-864. You don't really have a choice. As the petitioner, you have to, or the case will not continue. Right? Now, when it comes to being a joint sponsor, of course, it's your choice. This is something completely voluntary, and we really do thank all of our joint sponsors out there for being joint sponsors, because without you guys, immigration cases would not go forward. I married my husband, who's from Johannesburg,
the government
when I was in law school and I was not working, and I had been in college right before that, so I hadn't had a full-time job, and I did not meet the requirements for the affidavit of support. And my mom, thank you, Mom, was my joint sponsor for my husband, and I'll always be thankful because my dad did not want to do it. And my mom did it begrudgingly, not gonna lie. And 17 years later, I'm still married to my lovely husband from South Africa. And my parents now benefit from having a beautiful grandchild and everything from that relationship. But they were not happy about serving as a joint sponsor and signing these forms. And I totally get that, especially now that I am an immigration lawyer. I totally get that. Now, in most something I always like to tell my joint sponsors is that when you read the sponsor contract, it says that they can sue you back for reimbursement for federal means tested benefits. So what does that actually mean? That means, like, for example, if the immigrant got food stamps, if the immigrant got welfare, and so means tested benefits, means tested meaning that they're depend on income-based programs. Then the government in theory could sue you back for the amount of that. So if someone got welfare in the amount of $15,000 per year, in theory, they could sue you back for that, right? Now, in practice, that almost never happens. It's so rare, but in theory, it could happen. It is written right there in the rules, right? Now, usually they're not that. The good thing about being a joint sponsor versus a sponsor is that when you're a joint sponsor, it creates what we call joint and several liability, meaning that the petitioner, who is the main sponsor, is always primarily liable. So they would always go after the petitioner first, right? Only if they couldn't collect from the petitioner would they go to you as the joint sponsor. So, in most cases, my clients need joint sponsors, like situations like mine, where I was in law school, I was not earning full-time income, and you're not even allowed to work at all during the first year of law school support, bar association rules support, and so I didn't have any income. But of course, after I graduated from law school, I became a lawyer. I had plenty of income. So if something like that had happened, they would have sued me first, and I would have had the income to pay, right? So I always tell everyone, when you're thinking about being a joint sponsor, think about the risk of the person actually using a public benefit, the person who you're sponsoring. Most of the people I represent are like so anxious to get their work permits, start working in the US, be able to work. And so usually they're not that risky for using a public benefit, right? Because they want to work. They don't want to become a drain on the American economy, right? The second thing is that if the principal sponsor, if you're being a secondary sponsor, if you think the principal sponsor is going to be earning plenty of assets and income in the future, then they would be primarily liable for any of that. Makes them obviously not qualified for means tested benefits, but there are cases where there's what we call I-864 enforcement, and this usually happens in the cases of husbands and wives that are divorced. And so after the divorce, the person will seek that spousal support under the affidavit of support. You can totally do that. It is legal. But like I said, if you're marrying somebody, you want them to get their green card, it's just part of the process. You got to do it. There really isn't any other choice. It's either this person will not get their green card or you serve as the sponsor, right? So it's just a necessary part of the process for 99.9% of people that serve as sponsors. There'll be absolutely no effect to their life. I do some tips to try to decrease those risks. One of them is making sure that the person always has health insurance. You don't want them to go to, like, for example, public hospital, wrap up a bill, and then find yourself possibly being on the hook for that. Also, obviously encouraging them in helping them to find employment once they're employment authorized, doing all those things, because obviously building up employment being smart makes them obviously not qualify for means tested benefits, but it also helps them to get towards that 40 quarters of Social Security. The other thing is assisting the person in becoming a citizen as soon as possible. That's like they want to work. That is in their benefit. So I usually tell, like, if it's a marriage to a US citizen and you can apply for citizenship in 3 years under the special rule, I do it right at the 3-year mark, because as soon as that person becomes a citizen, you're off the hook on the affidavit of support. And so in marriage cases, it can be very quick because the person can become a US citizen only 3 years after having their green card. So the obligation doesn't go on forever. But obviously in other cases, I have some cases where, for example, the person's a parent and the parent doesn't really speak any English. So So they're not going to naturalize anytime soon. And those people, you're on the hook for a long time. Sometimes they come and they don't work because they're already elderly and they're retired. So they don't have social security quarters. Then they don't naturalize. They can't speak enough English to pass the naturalization test. And their sponsorship can go on indefinitely in that circumstance, right? So, it's just about being smart, thinking it through, thinking about, do I trust this person? Do I trust the primary sponsor to work hard, to not be going on food stamps and welfare, which the average person does not want to be on food stamps and welfare. Like that's like they want to work, they want to make money, they want to have a good life, and they're not going to want to do that. So really the risk is extremely low. But anyone who tells you that there is no risk is lying. There is. It is a real contract, and I recommend doing exactly what I was just doing, reading through the sponsor's contract. You can go on Google and Google I-864, and it'll bring you right to the affidavit of support page on the USCIS website. And you can look at the form, read the sponsor's contract, and make sure that you understand the obligations before signing. But it truly is a gift to serve as especially a joint sponsor for somebody, and help them get their residency. So if you are comfortable with that person and you're confident they're going to work, your risk is so minimal to signing the affidavit of support, and the benefit to that person is so huge. And it really is, as my people would say, a mitzvah to do something like that. It's a good deed. And so I highly encourage you to do it, but knowing and doing it in an informed way where you know the obligations and the risks. All right, guys, thank you. If you have any more questions, always feel free to reach out. Go to my website, www.sashavisalaw.com, or find me on YouTube, TikTok, Instagram, everywhere. All right, have a good one. Bye.